this round, if slightly rectangular table, we're about to discuss bribery and corruption in the context of the extractive industries. No, not dentistry, but the extraction of natural resources like oil, gas and minerals, more often than not involving huge companies in some of the poorest countries in the world. So we're going to explore the global picture first and then bring ourselves up to date by considering our own new Bribery Act and to see if it has teeth, which kind of brings us back to dentistry again. Now today I'm joined by Will Kenyon, a partner in forensic services at PricewaterhouseCoopers, Eddie Rich, who's the Deputy Head of the Extractive Industry's Transparency Initiative, and Owen O'Shea, who's Head of the Anti-Corruption Group at Lawrence Graham, who are also our hosts today, so thanks to them. Now, Eddie, if I could begin with you. Transparency Initiative implies that there's been a lot of opaqueness in the past, and we kind of know that historically corruption in the extractive industry, as I said, in poor countries, has often done their citizens a disservice. Why has that been the case over the years, do you think?
There are many reasons, Mark. When a country has natural resources, particularly if it discovers them very suddenly, it doesn't have the institutions to deal with this. This leads to all sorts of temptations and difficulties for the institutions to handle such an inflow, and that can have major effects on the priorities of a government. It can have major effects on exchange rates and on other sectors. It can be a large inducement for a different way of doing business. And the traditional forms of social contracts and tax systems become very, very different when you have one area of the economy which suddenly flows so much more money than it has done in the past.
Now, often in these countries that we're talking about, you've got the very weak rule of law and very poorly managed public sector institutions. But as someone pointed out, it does take two to tango. Mm-hmm. And transnational companies, perhaps in the past, have not had the squeakiest clean record in terms of their behaviour. Is that changing?
I don't know about whether it's changing. There's certainly a determination for more transparency. The theory goes that if there's more transparency, then of course there are fewer areas for unclean business to go on. So that's what so many of the activists in the area and so much government and corporate policy is around, trying to increase the light in the business and to also create a level playing field for all of the actors within it.
Yeah, there's a lot of talk, isn't there, of creating the level playing field, and I'm kind of wondering how easy it is just with transparency to, say, persuade businesses to do things differently and frankly to persuade sometimes dictatorships to do things differently.
Well, I mean, the people where you're going to make progress on transparency, you do have to have everybody around the table who wants to move in that direction. At least you need to have the government. I mean, in the Extractive Industries Transparency Initiative, it is really the reform governments, 35 of them, who are now implementing this. The more extreme cases of opaqueness and governments and nations that are working like that are not yet implementing this. But there have been others, very controversial countries like Nigeria, who have been implementing this now for about 8 years and have made a lot of progress. It hasn't solved the issue of lack of transparency, of corruption in that country. It can't by itself, but it's a step in the right direction and a very necessary step. I mean, you don't get good systems of accountability without the transparency being there in the first place.
Why do you think, I mean, there could be some people who argue that if corruption greases the wheels of commerce, especially when times are tough, you know, on the economic stage, does it really matter? I mean, I've heard our Bribery Act described recently as the right piece of legislation at the wrong time, almost as if it's a barrier to business when the economy's in trouble. But why, in your view, should the developed world worry about corruption in the developing world?
It's a matter of accountability. It's a matter of whose resources are they anyway. I mean, if you look across Africa and DRC, in Angola, in Nigeria, and the huge amounts of resources that are coming into those countries, and then these people in the past and in many cases still are not in any way benefiting from those. That has happened because there has been a breakdown of accountability, of social contract, and the only way to rebuild that contract has to be with transparency and then build on from there. But we need to know what's going on. The citizens themselves, not us, the citizens themselves need to know how much money is coming into the sector. How are those contracts being arranged?
And of course, these are some countries, aren't they, where, you know, you cite Nigeria, where there's billions of dollars of revenue coming in, and yet, you know, citizens living on just dollars a day. And if I can turn to you, Will, as we said, there is this kind of two to tango factor. What should businesses be doing now? And more importantly, why? Why has the climate changed? Why should businesses be thinking about best practice?
Well, I mean, I think there's been a global trend and a discernible one towards greater transparency, and particularly a focus on anti-corruption. I mean, corruption is recognised to be a very insidious form of you know, economic crime. It has devastating effects on the countries in which it takes place. It's a huge cost on business. I mean, it's a massive inefficiency in economic and commercial terms. And you know, it puts a brake on progress, it puts a brake on development, and you know, it really just does absolutely no one any good, except for, you know, the sort of kleptocrats who benefit from it. But it's, I mean, in fairness, you know, corrupt countries have this extraordinary sort of trickle down effect. So it's not just about people at the top, although they're often are the ones who are benefiting most in absolute terms, but because of the tone they set in the countries in which they rule, you know, then everybody's at it, because you know, particularly state sector employees simply are paid a pittance. It's almost understood that they will supplement their meagre income by you know, exercise or abuse of their office. And you just get it going on in all sorts of places, and there are horrendous statistics about the proportion of, you know, income that is spent on just dealing with corruption in some of these countries. I mean, you know, 20–30% of disposable income just being dealt with dealing with local police and anybody else you have to get around to you know, make your life work. So that's sort of the macro picture. In terms of corporates, they are increasingly faced by you know, a wall of legislation and regulation and you know, and intervention. And you know, one of the trends that we've seen a lot of is increased international cooperation in investigations and law enforcement. Particular axis between the UK and the US that's becoming very clear, but actually over the last few years we've seen a lot of stuff with European countries, Germany for example, and elsewhere as well. So there really is a trend. If you like, that's the negative motivation for companies to do the right thing. The positive motivation ought to be also that with all that going on, with all the other general trends towards, you know, more transparency, better governance, better business, there is the positive motivation that, well, it's the right thing to do. And when you look at it at the corporate level, you know, one of the things in my view that marks out really successful companies in this area from the ones that perhaps don't do so well and struggle with this issue is if you approach this as purely a compliance exercise, yet another box-ticking challenge along with everything else that you have to do in your day-to-day life, then that's hardly the best footing on which to mount you know, an anti-corruption and ethics program. If, on the other hand, you say, actually, as a business, this is what we stand for, we want to do the right thing, then you are on a better footing, and your people will be much, much easier to bring with you. So it's a communication issue, it's an educational issue, and all companies face this problem, because whatever, you know, we'll come on to, you know, some of the details of adequate procedures and all that sort of stuff, but at the end of the day, what you're trying to do is get your people into a position as an organisation where, you know, in whatever circumstance, they know what to do, they know what is the right thing. If they're in any doubt, they know where to turn, and that's kind of it. Obviously, there are many stops in between in terms of how you communicate that, the supporting mechanisms you have to put in place. But that, if you like, is the holy grail that organisations are trying to get to.
I suppose there's another incentive, isn't there, which is, you know, didn't seem to be the case 10 or 15 years ago, which is if, say, your business might be the subject of a merger acquisition, you can't afford, can you, to have some kind of corruption skeleton dancing in your cupboard any longer?
No, that's absolutely right. And you mentioned M&A is a very interesting case in point, because when you're going into new business acquisitions, new business ventures of any kind, perhaps setting up a joint venture in some countries where that may only be the only way to access those markets, getting into bed, as it were, with local players of one kind or another, many of whom will have more or less transparent relations with governments in those local countries. Anything like that, creates a new area of risk, an addition to your risk profile. So the whole issue of what sort of due diligence you do around those sorts of new ventures and arrangements is critical, and we've certainly seen a massive increase in interest in answering the question, well, how do we know we're not onboarding some kind of a compliance problem, either an existing infraction that hasn't yet been detected but is going to come onto our books when we acquire, or just a general problem, a general way of doing things that just is not in keeping with our, as an inquiring organisation, our standards of behaviour. I think a lot of companies are, increasingly concerned about that and are doing things about it.
Given that the extractive sector, oil, gas, minerals, uranium as an example of minerals, I mean, given that they're at the heart of so much kind of intense activity in terms, not least of which because they're depleting all the time, is that going to make transparency more difficult, or in a strange way easier, because the competition is so intense and the anxieties are so intense?
Well, on the one hand, I mean that competition, those anxieties will tend to create additional incentives and pressures to do the wrong thing, undoubtedly. Just as more general factors like difficult economic climates and so on will often act as motivators or drivers for perhaps inappropriate behaviour, whether it's corruption or fraud or what have you. But on the other hand, I mean, the extractive industries are immensely visible, and as we've just heard, I mean, these people and companies play enormous roles in the economies of the countries that they're doing business in, that they are extracting whatever raw materials it is from. So we can expect to see a huge amount of regulatory and law enforcement focus on that. In a sense, there's going to be nowhere to hide in that area. So I think that there are countervailing points there, but I think the general trend towards greater transparency, greater enforcement of anti-bribery laws and regulations around the world, is going to take us really in one direction, and that is more scrutiny of companies, more questions being asked about how they're behaving, and of course also looking at the, if you like, the demand side of bribery, the supply side. What are governments up to? And I think this is where initiatives like the EITi play a critical role in dealing with that side of the equation. And you can't solve this problem from only one end. You simply can't.
When the OECD made it plain that they'd like the UK to have a Bribery Act, or a replacement for the patchwork quilt of legislation that existed before, as we've discussed and touched upon already, that there is this idea, which is a sort of philosophical idea, isn't it, that somehow best practice spreads. It informs one nation, then another. It informs one business and then another. Is that a pipe dream, though, in some respects?
No, I think it's a reality. I think it's already happening. I think it driven in part by a determination on the part of law enforcers to collaborate on these things, recognising that things like corruption are inherently international, because it's usually the companies of one country corrupting, doing corruption in another country, such that there is an absolute need, and in a sense they are almost, despite the jurisdictional barriers and differences of law and so on, they are trying to get over those sorts of hurdles in a way that is driving their behaviour, and is driving then the perception of corporates that do business globally as well. And look at some very recent, well documented cases. It's all about cross-border stuff going on. It's never just in one country, or just about one country. So I think that is a very discernible trend, and we will see, we're going to see more of that, undoubtedly.
Okay, well, I'll just turn to Owen now. Owen may well indeed wish to comment on stuff he's heard already, but I would...
I'm in the unfortunate position of agreeing with absolutely everything that's been said so far, so I'm sorry not to be the controversial one.
Well, we'll soon put a stop to that. But I'm curious to ask you, Ida, as we said, we'd bring it back to our own Act, which is less than 3 months away. we have guidance of sorts. First of all, there was outrage in some quarters to the guidance and delight in others. What's your view?
Curate's egg, as they say, you know, good in parts. Some very good parts of the guidance have made it clear that some misconceptions about things like corporate hospitality and promotional expenses and so on are misconceptions, and that 99.9% of corporate hospitality, certainly as it occurs in the United Kingdom, isn't for corrupt purposes and doesn't constitute bribery. Similarly for things like promotional expenses and so forth. And there's also been some sensible and comforting things said about the sort of priority that will be given to very minor and one-off infractions of things like facilitation payments. And all of that, I think, was a good thing and necessary to calm the debate down a little bit, which was getting rather overheated in some parts of the media. On the other hand, the guidance does seem to have gone quite far in suggesting potential loopholes and exceptions from the Act, which, first of all, it wasn't really the job of the guidance to do. The statute did not expect or require the Ministry of Justice to do this. And I have to say, in my opinion, is some of the conclusions, or some of the suggestions at least, that exist in the guidance are questionable. And I'm on record as having said that companies should take a little bit of this with a pinch of salt, and they should adopt a prudential approach to some of these issues. One of them is the idea that a company, so a little bit of background I suppose I should say first of all. So Section 7 of the Act, which is the most controversial section, which applies to companies which can be guilty of bribery on the basis that somebody acting for them, performing services for them or on their behalf, has paid bribes in connection with their business. Now, that part of the Act applies not only to UK registered companies, but also to foreign companies which have any business presence in the United Kingdom. And the test is carrying on business or part of a business in the United Kingdom. Now, the Act doesn't say what part of the business, so it must mean any part of the business, in my opinion. And what's been suggested by the Secretary of State for Justice in an article that he wrote in the Financial Times last week, and in the guidance as well, is that a company which merely lists its shares on the one of the UK stock exchanges, might be exempt from the Act altogether because it might not be carrying on business in the United Kingdom. Well, that's the sort of defendant-lawyer argument that one might hear if these cases came before the High Court and went before the Court of Appeal and went even before the Supreme Court. Those are the sort of rather technical arguments that a lawyer like me might well run, and I certainly don't want to say that they won't be successful, because one of these days I might be running an argument of that kind. But I would say this, that it, as a basis of policy and as a form of government guidance, companies ought to be careful about relying too much on this sort of kite flying. And it is a bit surprising that the government and the Ministry of Justice saw fit to draw attention to this particular, if it is a loophole, why attention is being drawn to it I don't quite understand. Nevertheless, it's fair to say the law isn't decided on this, and it's possible that the argument is an accurate one. But I can understand how pressure groups such as Transparency International and others were a bit taken aback when they saw that idea being bruited about, as it were. There are other slightly surprising parts of the guidance. It says, for example, that for small companies, it might be perfectly adequate as a procedure to again, sorry, some background. One of the parts of the Act, again on Section 7, you have a defence if you can show that your company had adequate procedures designed to combat bribery by your agents and people acting for you. And so the main purpose of the guidance was to describe what the government thought could be adequate procedures. And most of the descriptions in there are uncontroversial, and I would go along with them, although some of the phraseology does seem to be a bit less strict than the original draft. But one part, again, it suggests that in a case of a small company, it might be sufficient simply to a verbal instruction to the staff not to pay bribes. You could rely quite heavily on that, I think was the word used by Mr. Clark. And again, this rather ignores the inconvenient legal argument and legal fact that the burden of proof of the defence is actually on the defendant. So proving a mere verbal instruction, even if it was a one-off, it was in writing or an email or something of that nature, that is adequate. Even in the case of a small business, it seems to me a fairly risky way to go about things. It might be enough, but as I say, with the burden of proof on the defendant, I'd suggest taking a good deal more care on that. So, as I say, curate's egg on the guidance. It's good that it's there. It contains a lot of good sense and helpful material for companies and businesses. It can't be ignored and shouldn't be, but I think there are parts of it where a little bit of caution should be exercised.
I was curious when you mentioned the word facilitation payments, because the guidance again was a little bit vague about that. It was almost to say, well, actually, we understand that this happens, and the Foreign and Corrupt Practices Act in the US permits them. So I was just curious. I mean, I'm asking this as a kind of layman's question, which is, if I'm in some emerging economy somewhere and my American competitor is paying grease payments, is it a defence that I had to do that to stay in the game?
No. Not under English law, it's not a defence. But I must say I probably diverge from some of the activist community in relation to facilitation payments, and I do understand the serious dilemmas that face companies who are trying to do honest business in a dishonest environment. I would be very, very slow personally, even on a moral level, to condemn someone who found themselves apparently with perishable goods or with important medical equipment that's held up in a port, and the only way of releasing it so that it gets to its destination on time. I mean, NGOs have this problem, Oxfam and other people have this problem, medical supplies and food supplies going through to disaster areas. Are we really going to say that these people ought to be prosecuted if the only way that these valuable materials should be released?
These are the interesting dilemmas of the Act, though, aren't they? Because it's kind of interesting that with less than 3 months to go, there is a greyness about.
Yes. And
that's probably inevitable. But But I
think the hint that's contained in the guidance and the hint that's contained in the SFO guidance, the prosecutor's guidance, as well about facilitation payments, is that one-off circumstances, unless it's part of an egregious scheme over time, deliberately to do this and to corrupt the system, are going to be treated with a good deal of leniency, I suspect.
What do you think of the situation if my company forms a joint venture with an overseas outfit and it's found that the joint venture partner is practicing, corrupt practices? I mean, am I liable as part of that joint venture?
It depends on your relationship with the joint venture partner, is the short answer. If your joint venture partner is performing services for you at the relevant time, then yes, you are liable.
And of the 4 offences, which include paying
unless you have your adequate procedures
in place, unless I've told them verbally not to do it. But
well,
but I'm curious again about just to remind people that there are principally 4 offences: paying a bribe, taking a bribe, bribing an overseas official, and failure to have adequate procedures in place to prevent the taking and paying of bribes. But if I'm working overseas, let's imagine in the extractive sector, and I want to take a foreign state official out for a lavish, well, no, I mustn't use the word lavish, a dinner. A
non-lavish dinner.
Am I already crossing a border?
So many of these cases are matters of judgment and depend on individual circumstances. The key to bribery is an intention to cause the receiver of the benefit in question to do something which he ought not to do, in layman's terms, to do something wrong as a result of the benefit. Now, if you have a meeting with a state official and you say, oh well, let's go and have a sandwich, and you happen to be the one who pays for the sandwich, there's no way that could be interpreted as being intending to corrupt that official in any way. On the other hand, I'm afraid I am going to have to use the word lavish. If you take them to the best restaurant in town and pay for an absolutely enormously extravagant event, and this happens on a very regular basis, and one is just about to apply for a contract from that official or from his department, then clearly the inference is going to be that that's smelly and questionable. So I'm afraid I fall back on the traditional lawyer's answer, which is that it all depends on the facts, but I hope the context will be evident to most people. I mean, I'd make this general point. I think most people understand and have an instinctual sense of where the lines are. If something feels wrong, if something appears to one as something that one wouldn't want to be widely known about, then you should probably stop and take stock.
Okay, now many business people watching this, I mean, will be asking themselves, what are adequate procedures? And probably reading along with everybody else that the Act is more or less likely to be tested ultimately in the courts, isn't it? That's where the greyness will be stamped into black and white, will be in the courts. So, Will, I'm just curious, you know, what would your advice be? Businesses small or large now, in the context of our Bribery Act, less than 3 months to go, what should they seriously be doing? Okay,
well, I mean, the game plan at one level is very simple. Is assess your risk. You've got to figure out where your exposures are, and businesses are, frankly, not terribly good at doing that in our experience. So they need to really get under the skin of their own business and understand what are the activities that expose us to potential bribery risk, wherever it might be in the world. And that's crucial because, you know, like any other risk, and businesses are generally very good at managing risk. It's with a bribery there seems to be a bit of a blind spot sometimes. But you know, you cannot hope effectively to mitigate any kind of risk if you haven't properly diagnosed it. I mean, what is the medicine to be taken if you don't know what the disease looks like? So that's absolutely crucial. It's also crucial because, and I think I share the view that, you know, that there are a lot of good things in the guidance, and one of the good things is a recognition of the concept of proportionality. That is absolutely critical. So, you know, it really matters what your risks are, what sort of resources you have to mitigate those risks and so on. Those are all relevant factors. There is one thing though that worth saying, it isn't just about size, and you can well imagine that you can have a very large company or group doing business in low risk places in an inherently low risk sector, and compare that with a small company that's, you know, perhaps in the extractive industry is trying to acquire mining concessions in one or two difficult places. You know, clearly, no one in their right mind is going to suggest that that large company I just hypothesised about has a bigger risk profile overall than the small, you know, let's say mining company. So there is a challenge for corporates, which is that they may be outgrown to some extent by their risk profile, and they'll need to figure out what to do about that. But clearly, where you are a smaller company, you have the advantage that, you know, your senior management, where the top level commitment is supposed to be coming from, which is one of the essential ingredients in adequate procedures, we're told, is closer to the action. So whereas in a very large company you'd expect quite elaborate mechanisms just to make sure there is a proper connection between the tone from the top and what's going on in the front line, that connection should be easier to establish in a smaller company. So the degree of sophistication and the level of resource and so on required ought to be broadly commensurate with the size of the company. But you just need to be careful that, you know, you can still have a high-risk small company and a low-risk large company. So we need not to be overly simplistic about that. Once you've got your risk sorted out, then you should be asking yourself, well, what do we already have in place that would mitigate those risks? Most companies, hopefully, are not starting from ground zero on this. You know, they'll have financial controls, they'll have other things in place. Most companies have a half-decent code of conduct these days, may need a bit of tweaking. But a lot of this stuff will be there. So it's about how do we build on what's already there. And once we've figured that out, then we're in a place to do a sort of gap analysis. So what are the things we need to still fix and remediate to get us to a position where we could coherently argue, yeah, we think we have adequate procedures in place. And, you know, I'm sure, you know, in different ways, all of us around the table have experience of helping our clients and so on through that sort of a thought process, and certainly we're seeing a lot of activity in that area. The devil is in the detail. It's not a one-size-fits-all. answer, and there are all sorts of legitimate different right answers to the question of what do we need to put in place. But companies ought to be getting on with it. What I would say is don't panic. We talk about only 3 months. That's not a heck of a long time for a complex organisation to put adequate procedures in place if they are starting from a low base. In fact, probably they won't make it. But that's not grounds for panic. They should be getting on with it, because I think the direction of travel is important. And there's quite a lot of sort of tone out of the SFO and so on, that they will recognise that if people are showing the right intent and the right focus, then that will be certainly taken into account. This is a marathon, not a sprint. It's not about having adequate procedures on the 1st of July. It's having adequate procedures from or about the 1st of July and thereon in perpetuity, as long as the Bribery Act is with us.
Eddie, I know that obviously your transparency initiative is not specifically linked in any way to the Bribery Act, but presumably for people watching, you'd say that just transparency as a principle it's pervasive everywhere, or should be.
This has been a very interesting debate for me. I haven't been following the discussion about the UK Bribery Act that closely, and I'm sort of looking at those links, and some of the difficulties that are being described are very much because of the number of actors there are in the game, and that it is very difficult to analyse the relationship where only two sides are expected to be in the game. The need for governments to be involved and to enter this in the right spirit creates the environment for this to be a much simpler activity for the companies. And so, we spoke about Nigeria, and Nigeria's they've had periods, and hopefully are still in a period with some strong government commitment to improve the management of the extractive sector. Then if in that case, then all of these things become much simpler. The need for working with those third country governments, for them to understand the environment in which these companies are working in, is clearly going to be a priority.
So, and perhaps a final piece of advice to the business community from you then.
My advice, analyse your risks, take proportionate measures to mitigate them.
Okay, and that was short, succinct, but to the point. I'd like to thank Will, I'd like to thank Eddie, and of course I'd like to thank Owen from Lawrence Graham, and of course, thanks as ever to you for watching. Bye-bye.